What legal rights do you lose the moment you die? Can someone who is not yet born inherit property? Can the law protect a person who doesn't exist yet or one who is already gone? Can an unborn child sue you? Can a dead person be defamed? You may be alive today, but do your rights really end with your last breath? Is it possible to become a legal heir before you are even born? If someone dies during a court case, does justice die with them? This is Mr. Ask Me Anything Easy Learning Site. Dear friends, in this video series, I'm going to simplify the concept of legal status of dead person and unborn person. Stay till the end of the video to get the complete answers of those questions. Firstly, let me come to the legal status of a dead person. It is the legal principle that the moment a person dies, the legal personality ends. That is, law no longer sees them as a person and doesn't have rights or duties anymore. They can no longer hold rights or duties, but the law still protects certain aspects. Right to reputations after death. Section 499 of Indian Penal Code and Section 356 Clause 1 of Bharatiya Nyaya Sanhita explanation number 1 says, defaming a deceased person is punishable if the statement would harm their reputation if they were alive and affect their family or close relations. Right to dignified burial is recognized under Article 21 of the Constitution, that is right to life and personal liberty. In the case of Permanent Katara versus Union of India in the year 1989, the Supreme Court implied that the dignity extends even after death. Legal proceedings can be continued even after the death of a person. In civil cases, it continues through legal representatives under Order 22 of CPC. However, in criminal cases, it is generally abated on death of the accused. A person can make a will that takes effect after death. The estate, that is everything a person owns at the time of his death, is distributed either by testamentary succession, that is will, or intestate succession under laws like the Hindu Succession Act 1956. Secondly, legal status of an unborn person. In legal principle, an unborn child doesn't have legal personality, that is, law doesn't see them as a person and doesn't have rights or duties, but they are treated as a person for specific purposes, especially for its benefit. If you look to the property and inheritance right, Section 20 of Hindu Succession Act 1956 says if a person dies without a will and his wife is pregnant, the unborn child will get a share in his property, but only if the child is later born alive. Here, a person who dies without making a will is called intestate. Here, will means a legal document in which a person writes how their property should be shared after his death. Section 13 of Transfer of Property Act 1882 says property can be transferred for the benefit of an unborn person through a wife, first then to the child after the death of a wife, provided the child is born alive. Legal maxim: Nascituras pro am nato habitur quotiens de commodis aius, meaning an unborn child is considered born whenever it is to their benefit. It is also provided in a criminal law for their protection. If we look to the sections 312 to 316 of IPC or sections 88 to 92 BNS says causing miscarriage, death of a quick unborn child is punishable. Example, section 316 of Indian Penal Code or section 92 of Bharatiya Nyaya Sanhita. Death caused by an act amounting to culpable homicide to an unborn child shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. Medical Termination of Pregnancy Act 1971 also sets limit on abortion, protecting the fetus under certain conditions. The Supreme Court meticulously analyzed the provisions of the Medical Termination Pregnancy Act, particularly Section 3 and Section 5, concerning the permissible duration and condition for medical termination of pregnancy. If we look to the Medical Termination of Pregnancy Act 1971, under Section 3 Clause 2 Clause B allows termination up to 24 weeks with the concurrence of 2 registered medical practitioners if there are substantial fetal abnormalities or significant risks to the mother's physical or mental health. Section 5 of the same Medical Termination of Pregnancy Act 1971 empowers registered medical practitioners to bypass the gestational limit in cases where termination is immediately necessary to save the mother's life. Here, gestational limits refer to the maximum number of weeks of pregnancy after which certain medical actions like abortions are not legally allowed. Thus, in law, both the unborn and the dead may not be living person, but they are not outside the protection of justice, whether it is inheritance, dignity, or defamation. The Indian legal system recognizes their limited rights to ensure fairness and morality. Thank you for watching Mr. Ask Me Anything. Please do like, share, comment, and subscribe. For this video series, I am signing out. See you in the next video. Till then, take care.